We have a quorum, so thank you. Let's start the meeting. But we have to invite the administration in first. And last time we started clause by clause scrutiny, and we have reached page 6 of this marked up copy. This thick stack of document, and we're on page 6. And in a moment, we'll ask the administration to continue reading out the copy for us. So I see that the administration has come in, and we'll ask them to continue to read them out. Members are very busy. They have to attend several meetings at the same time, and perhaps we can pause if necessary when we reach some parts of the paper, and then we will pause there and resume reading the clause later. So when members are ready, we can resume. Now, Permanent Secretary, last time we were on page 0006. I'm sorry, beg your pardon. We're on page 0006, 4B. So over to you, administration. Please continue to read it out, and we can pause for discussion if necessary, or we can just pause there pending discussion later. Thank you. Maybe I'll defer to Mr. Chan to continue reading it out for us. Thank you, Chairman. 4B is about Code of Conduct and Codes of Practice, COC and COP. It's an addition. Subsection 1 is that the board may issue codes of conduct and codes of practice that it considers suitable for providing practical guidance in respect of this ordinance. Subsection 2. A code of conduct or code of practice may A. consist of a code, standard, rule, specification, or any other documentary form of practical guidance prepared by the board or any other body or authority. And B. may apply, incorporate, or refer to a document that has been formulated or published by a body or authority, either as in force at the time when the document is so applied, incorporated, or referred to, or as amended, formulated, or published from time to time. Subsection 3. If a code of conduct or code of practice is issued, the board must, by notice published in the Gazette, A. identify the code, and B. specify the date on which the code is to take effect. Subsection 4. The board may from time to time revise the whole or any part of a code of conduct or code of practice. Subsection 5. If a code of conduct or code of practice is revised, the board must, by notice published in the Gazette, A. identify the code or part revised, and B. specify the date on which the revision is to take effect. Subsection 6. The board must make a copy of every code of conduct or code of practice available for inspection by the public, free of charge, at the office of the Secretary during normal office hours. Subsection 7. A code of conduct, code of practice, and notice published under subsection 3 or 5 are not subsidiary legislation. Subsection 8. To avoid doubt, different codes of conduct or codes of practice may be issued under this section for different purposes of this ordinance. Thank you. So, members, any comments? We're talking about page 6 of this marked up copy, this huge stack. A question for the administration on drafting. Now, there are similar provisions in for other statutory bodies and organizations, right? Anything you want to highlight? Any differences? Thank you, Chairman. In similar legislation, there are also provisions for code of conduct and codes of practice. We need to have some flexibility because the COC and COP will have to be revised and updated from time to time, and new arrangements will be reflected by doing so in the code of conduct or codes of practice to reflect the operation of that discipline. For example, CAP 652, the 562 Broadcasting Ordinance, and CAP 667, there are also similar provisions. For other professions like medical doctors, they also have their own codes of conduct. Mr. Albert Chan, 5 minutes. Chairman, we have been very busy lately. Now, I may not have fully familiarized myself with the administration's papers as a result. I think I pointed it out during the last 2 meetings or so in relation to the codes of conduct and codes of practice, the views expressed by deputations, and secondly, the administration has emphasized time and again that the COC and COP are in line with those in the EU countries, and my point is that if we draw reference from other jurisdictions, it should not be selective. It should be comprehensive. So I don't have a full picture whether just by reading these provisions, all the requirements have been met. So when we come to the clause-by-clause examination, it's really hard for me to comment without having a full picture. So will the Secretariat also remind us that when we come to the clause-by-clause scrutiny stage, if there are comments on particular provisions, can the Secretariat remind us whether these issues have been addressed or the issues are outstanding? Now, before I allow PS to remind me to answer a question, let me remind members that the Secretariat has prepared 2 papers, and I believe they have been afforded to members. The first one is an information note on regulations governing the definition, registration, and manufacture of medicinal products in the European Union. And that's a PDF file forwarded to members. The other paper is on major issues of concerns raised by members and deputations. And that's CB bracket 21943/1314 bracket 02. Again, the paper has been circulated. And Mr. Albert Chan has referred to the relationship between the COC and COP and the EU countries. Now, I'm talking about the actual provisions here on page 5 and page 6. And we may not immediately see the link here. So maybe the administration, PS, legal advisor, or the Secretariat can help us and remind us whether the deputation's views have been addressed, whether these issues have been addressed, whether they're left outstanding. Yes, indeed, there have been discussions on this part. So when you're asking me to discuss this, since I can't see the link, I can't answer whether I support this amendment.
睇法就係話，因為我哋都明白幾個會一齊開，議員有時可能走嚟走去嘅，咁去到某一條。
When we come to a particular issue, we may not understand so clearly, and perhaps we can pause there and have a discussion later and then resume reading the provisions later. Perhaps if you think the issue is still not clear today, we can come back and discuss this issue later. We won't just let it go easily, because last time we mentioned that there are technical parts of the ordinance, and we can go through the provisions first and pause for discussion. And I'll defer to PS to take your question. Thank you, Mr. Chan. In fact, this COC and COP was a matter of members' concern. In previous meetings, there were questions asked, and there were also views expressed by members of the public in the public hearing. For example, when the board revises the COP or COC in the future, will there be a lack of transparency? And in fact, in the LC paper 1543/1314, we have explained in detail that the individual and the COC and COP will be formulated in relation to the members, including authorized sellers, licensed traders, and so on and so forth. And there are the relevant COC and COPs issued. And in Annex 2 of the paper, we have set out the details. We have set up a working group for the respective COCs and COPs, comprising members from the individual sectors. We've also invited the public to express their views, and Annex 2 sets out the COCs and COPs and their respective working groups and their membership. These codes have been discussed by the working groups before they're submitted to the board for approval, and they're required to be gazetted. There is a high degree of transparency. The board will not just revise the codes without letting the public know about it. There is a need to revise the COC, COPs, because we need to have a clear set of codes. So I understand Mr. Albert Chan's concern. We need clarity, and I just want to point out that on these working groups there is participation from various organizations. What about the EU-related codes? I don't think it's directly relevant. Now, this bill is very complex, Mr. Chan. It's about the definitions. For example, pharmaceutical products, medicinal products, and authorized persons. Now, what is the definition in EU countries? And in fact, we have drawn reference from their definitions and incorporated their definitions, and we have set out in detail in the papers. In the COPs in the future, we will also draw reference from the experience in regulating the profession in EU countries.
Mr. Albert Chan, I'm still confused. Are we talking about the COP and code of conduct? So I don't know whether or not you've incorporated the points raised by the deputations. Well, there is a paper, CP 1914-1314 bracket 2. You will find the points raised by the deputations, whether they were in support or not. And this is actually in response to requests by members that the Secretariat has prepared this paper. It's on page 2, section C, where you find the list. Regarding the reference paper, I think you'll find all the details in the third column. Chairman, I don't want to delay the scrutiny of the bill. I just like to reserve my position in respect of these provisions. I'll certainly 4B is the Code of Conduct and Code of Practice has been is a new edition, and I think we can pause here and reserve it for discussion at a future date. I think subsection 7 said the Code of Conduct, Code of Practice and notice published under subsection 3 and 4 are not subsidiary legislation. There are still some members of the trade who are concerned that you may bypass the need for legislation and impose regulations on them by way of subsidiary legislation. For example, who is the person holding the key to the receptacle for poisons and so on. So what I'd like to know is how are you going to deal with the concerns of the trade, and what is the administration's response? Thank you. Thank you, Ms. Matt. First of all, let me clarify that important regulation, for example, the regulation regarding who should hold the key is in the principal legislation, whereas the Code of Conduct and Code of Practice involves the detailed operation of the trade. I understand that the interpretations have many concerns, and that is why the Department of Health has set up so many working groups. These Code of Conduct and Code of Practice is the result of detailed discussions with these stakeholders. At the public hearing, I remember that some of the deputations have confirmed that at the working group meeting, each and every item in the Code of Conduct and Code of Practice have been discussed in detail. So, and this shows that we've actually consulted the trade and the profession before the PPB endorse the Code of Conduct and Code of Practice. If these codes were to be amended, I believe that we have to do so through the working groups and talking to the relevant parties. The representatives on the PPB would include representatives of pharmacists, doctors, legal practitioners, and the 2 universities. So the whole process is transparent, and the trade will have lots of opportunities to give the inputs, and also this will have to be gazetted. We like to explain that we do not want to promulgate the Code of Conduct and Code of Practice by way of subsidiary legislation, because these codes may need to be changed or reviewed from time to time, and if we were to take the subsidiary legislation route, it will be a very long process. But it doesn't mean that there won't be any consultation. We definitely will consult the stakeholders through the working groups. I also believe that I think through members and the trade and this panel, I think the parties concerned can raise questions. I think, Permanent Secretary, you also have to understand why the trade is so concerned about the Code of Conduct and the Code of Practice. This is probably because this has to do with the legitimacy of the PPB regarding, for example, its composition and so on. And this may show that there had not been sufficient consultation. So I think the Bureau should do it comprehensively. That is, regarding the composition of the PPB, should there be any change in its composition, I think you have to ensure that it is credible. Otherwise, if it come up with Code of Conduct and Code of Practice which is not acceptable by the industry, it would not be desirable. Perhaps I can also further assure members that in our response to the questions raised by Vincent Fang, that the content of the Code of Practice and the Code of Conduct is not part of the subsidiary legislation. If anyone should breach these 2 codes, he would not be considered to have broken the law. He's only violated the code, and this may affect. I think the consequence is that if that person were to apply for a license and the person is obliged to comply with this Code of Conduct and Code of Practice, so any violation of the code may result in disciplinary actions. If the person has repeatedly violated the codes, then he might not have his license renewed. So it's not equivalent to breaking the law. I think that is exactly the concern of the trade. You don't need to amend the law. The person may not have broken the law, but it will still affect his license and his livelihood, and that's why they are so concerned. with the after you've added the code of conduct and the code of practice, and if they have no confidence in the PPP, and that is why they're so worried. So I think you need to do more to give confidence to the trade. Thank you, Ms. Matt. We agree with that, and that's why we've undertaken that even after we've promulgated the code of conduct and code of practice, there will be further consultation, there will be briefing sessions to brief the trade about the codes of conduct and codes of practice. We've already promised to do that. And within the working group, the relevant, I think the stakeholders will be able to participate in the working group. We want more members of trade to participate so that they can have confidence. Both conducts will serve to enhance the standard of the profession, and also to ensure that there is clarity and consistency and that the same standard applies. Permanent Secretary, I think in response to Ms. Mack's point, in the paper prepared by the Secretariat, page 7b, the trade has some concerns about the composition of the PPP. They think that it's not transparent enough and doesn't fully represent the trade. If you empower the PPP to formulate these codes, and if the board doesn't give the industry the confidence, then they will be worried. And I don't think you've answered that question raised by Ms. Mack. Regarding the composition of the PPP, at one of the earlier meetings, we've already said that the Pharmacy and Poisons Ordinance regulates not only drugs but also persons. It regulates the manufacture, the sale of drugs, the pharmacist, and so on. So the ordinance is very complex, and we believe that the structure, which was enacted several decades ago, would need to be enhanced. So the current amendment and the amendment to the ordinance are two separate issues. If we were to revamp the principal ordinance, it will be a very complex exercise. We've also promised that regarding the regulation of the registration of pharmacists, whether or not they should be separate from the registration of drugs. We promised that when we review the manpower of the then we will discuss that. And should there be any changes to the composition, then the composition of the PPP will also be changed, because we're going to separate the regulation of the practitioners and the regulation of drugs. Well, some members have just arrived. I'd like to remind them that we are now on page 6 of the marked up copy. We are on 4B, the Codes of Conduct and Codes of Practice. At earlier meetings, members have raised concern about these two codes. Ms. Albert Chen. I'm looking at the document prepared by the Secretary regarding the major issues of concern, and I'm looking at section C, and it says here that the major concern, there are major concerns about the COP and the COC. And the paper also gives the response given by the administration, and also the public consultation exercises undertaken, and then a list of reference papers, CB 21522, 13, 1401 through to 02. As I said at the beginning, we are now at the clause-by-clause stage. The framework, so we've accepted the framework for the ordinance, and basically we will simply look at the text, and if they are in order, then it's fine. But regarding major issues of concern, C, it says the question here is whether or not the authorization is proper. So in the Code of Conduct and in the COC and the COP, Is your response accepted by the trade? I don't know whether we have discussed this point yet because I missed some of the early meetings. Have you resolved this issue with the deputations? If the basic principle has not yet been agreed upon, and now we're talking about the code of conduct and the code of practice, I really don't know how we should deal with it. That, Mr. Albert Chan, at an earlier meeting, there was a discussion on this subject, and some colleagues have pointed out that different views were expressed during the public hearing, and our view was that there were divergent views. There were some who support the inclusion of 4B into the bill, but others were against that and expressed a concern. Now, I understand that, Chairman. I was also present. But does this Bills Committee have a decision on this? Well, we know that some members have expressed a concern, and the government has offered its explanation, and some members still have reservations, and that is why we've decided that we will start the clause-by-clause scrutiny of the bill, and when we come to this part, and if members have any questions, then they can try to lobby the administration and see how the government respond. If the government gives us an explanation, fine. Otherwise, we may need to go back and move CSA ourselves. Chairman, I'm not, familiar with this particular profession. Now, if the proposal of empowering, we're talking about two levels. First of all, is any objection in principle, and if there is doubts regarding the principle, and through technical amendments, if we could deal with those issues, then it's fine. But the question is that the deputations and the stakeholders, and I'm talking about the part highlighted in subsection C. Namely pages 5 and 6 of the marked up copy, that is section 4B. Regarding the deputations concerned about the question of empowerment, is that proper? Have we addressed all those issues by way of the bill, or do we need any amendments to the provisions or the text in order to satisfy the to allay the concerns of the deputations? I don't know. Perhaps our legal advisor and the Secretariat can give us some information here. That is in respect of the concerns raised by the deputations. If we just go through the scrutiny of 4B, does it mean that all the concerns raised by the deputations are swept under the carpet or what? All right, point taken. If we cannot resolve this issue today, and I must emphasize that at earlier meetings we came to the view that there are many technical amendments in this bill, and the deputations have not raised any particular concerns.
So, if necessary, we can go back to those issues, see if it's a matter of principle or whether the amendments can address the concerns. We are doing the clause-by-clause examination, but it doesn't mean we cannot further discuss the issues. If members think that things are still not clear, we can have another discussion, and I can ask the Secretariat to give you some information. Now, Chairman, of course, if I am familiar with the with this topic, I can move amendments, but the point is I'm not familiar with it, and I have many questions. It's all right, we can continue to discuss them. Chairman, you are very familiar with the topic, and Chairman, perhaps you or the Secretariat can help us. Issues raised by deputations that are still unaddressed, that are still outstanding. The administration has given us answers, but it doesn't mean that these issues have been dealt with. Now, my recollection is that in previous discussions, a deputation was of the view that it was not appropriate to have this provision on COC and COP, that is CAP 138, should not empower the PPB to such an extent as to formulate COC and COP. But I also recall that many written submissions received were in support of it. So I will defer to PS to explain further in a moment. Now, is it the case that all deputations and members are supportive of this provision? There are questions, of course. In the end, whether amendments are necessary. Now, I asked the PS just now in our discussion whether this is something new or whether there are already similar provisions for existing regulatory bodies. And in my recollection, no deputation has commented in or made adverse comments on the 8 subsections under 4B. I recall one deputation objecting to the concept of empowering the PPB under CAPS 138 to do so. But I also heard deputations saying that there are statutory bodies and regulatory bodies also similarly empowered to, in a similar manner. Anything to supplement? Over to you, PS. Thank you, Chairman, for your explanation. Mr. Albert Chan is not familiar with the trade, and let me give you some background. This is not the administration's recommendation. After the drug incident, back then in 2009, there was a review committee, and they put forward recommendations. It's one of the 79 recommendations put forward that require legislative amendments. And in the public hearing, the deputations concerned, in short, is about whether to regulate the trade or not. In the existing ordinance, the Pharmacy and Poisons Board is not empowered to formulate any COC or COP, so there is no code at all. And there are several professional bodies in the discipline suggesting that there are 3 sets of codes formulated by these 3 bodies, and they are not set out in great detail, only a page or so. So if the board is empowered to formulate COP or COC, we can have a standardized code that can be observed by everyone in the trade and also have some kind of binding effect, although it's not part of the legislation. It through imposing licensing conditions, the people in the trade will have to observe the codes. So it's not it's a matter of whether to regulate or not. And at the public hearing, a deputation objected to empowering the PPB to formulating COCs and COPs. And it's of the view that the respective associations can formulate their own codes. Now, Mr. Chen mentioned views not in support. And indeed, there are deputations supporting the recommendation. We've set out the deputations in 1810/1314, and we have a number of deputations. For example, one for chronically ill patients, and another organization, and also one for the Council of Social Service. And I mention these deputations because, of course, people would like to see a standardized code regulating the sellers of and traders of pharmaceutical products. The code is not part of the bill. there will be working groups, and there will also be the participation of professional bodies in formulating the codes. Okay, I'll go back and look at it more carefully. But my concern is that as we're scrutinizing the bill, and as you know, things are really hectic, and we're hastily going through the clauses. Of course, we can go back and discuss a particular clause, but let's say if the BC in the end may agree that there is no problems, but at this stage, maybe we have neglected amending certain provisions to address certain issues. Then eventually we might have to veto the whole bill, and it will be problematic. So as we carry out clause by clause examination, if it's a matter of technicality, let's say if we can make adjustments, additions, deletions to address the technical issues, we should do so instead of waiting till the end when we veto the whole bill. Mr. Chan, we're very concerned as well. That's exactly what we're doing, because the COC and the COPA are very important, and they are controversial among some deputations. Now, as we come to this part, if like you say, this is happening, I can say that I can so-called suspend or freeze this bill. It doesn't mean that we're endorsing it at the moment. This is also a concern because members are very busy rushing through meetings. We don't want to miss out anything, and we will definitely keep an eye on it. Maybe we have reached this part. It's 11:37 a.m. now, and there are still matters matters outstanding, and we will just suspend this part, and we won't let it pass. So please put it on record, Chairman. At this stage, I reserve my position. Perhaps members might wish to go back and have a better understanding of the issue. Please tell me, and I will go back and do some research. We can pause here. It doesn't mean after reading it out we are going to endorse this part. Mr. Wong Ting Kwong. Thank you, Chairman. Now, when we discuss the policy and at the public hearing on this issue, I have the impression that the views are diverse on the COC and COP. Of course, for members of the public, they support this amendment. For the trade, they are concerned about regulation over the trade, and they are either concerned or objecting to the amendment. Of course, as a electrical member, I am more inclined to consider the interests of the public. The incidents happened before we have this bill to revise the ordinance. That's why I support the bill. At the same time, there are still doubts in the minds of people in the trade on the COC and COP, and these issues are not yet addressed. We've come to the clause-by-clause examination stage. I hope the administration can clarify their answers. Basically, on the functions of the Pharmacy and Poisons Board and also the working group, what about the composition of this working group and the board? If there is participation from the trade, it will definitely allay the concerns of the trade. Then the ordinance can then take effect more smoothly. I hope the administration can respond to these points at this stage in time. And the trade is still trying to meet with electoral members to express their concerns. This is what we all know. Unfortunately, we are really tied up here because of the Quorum Bell, and we simply cannot meet with the industry practitioners. So I hope we can all help to make our work smooth, including the scrutiny of this bill. Permanent Secretary, perhaps you can also consider dealing with the issues later. Perhaps Mr. Albert Chan's mind was focused on other matters earlier on. He might not have had his heart fully committed to the Bills Committee's work. P.S. Thank you, Mr. Wong. We understand the industry's concern, and we try to incorporate, or we try to have members of the trade or the industry at the working group. For example, I understand the pharmacist associations, and there are 3 of them. They have different COCs or COPs, and there is therefore a need to standardize the codes. And the working group on the Code of Conduct for Pharmacists have 5 members who are representatives of the Hong Kong Pharmacists Association, and also another 5 from another professional body, and also 5 members from the Relevant Unit of Chinese University, and other 5 members from the Hong Kong U. So you can see we try to be as representative as possible in the working group, and each and every provision in the codes will be thoroughly discussed by the working group before it's submitted by the PPB for approval. So the process will be very transparent, and if other organizations would like to join, we're happy to invite them to take part in the discussion. And there will also be public hearings and briefings. We're going to make publicity effort. So I hope this can address members' concern. And I also agree with Chairman that we can revisit the issue for further discussion if necessary. I just want to point out that for the draft code, for the views expressed is a matter of whether to regulate the industry or not, because at the moment the ordinance doesn't empower the PPB to formulate the codes. The deputations have no particular view on the codes themselves. They are just objecting to the power given to the PPB to formulate codes. So it's a matter of yes or no. And at the time when the review committee formed based on the drug incidents make some recommendations.
Chairman, I think Mr. Vincent FANG concern was basically about the professional bodies. I'm more concerned about the concerns of the industry. For example, who is to be responsible for keeping the key? I think right now the system at the moment is very confusing. So in future, there will be criminal liability involved. But I don't think we never heard about you mentioning the trade. I've been in touch not only with the professional bodies, but also the pharmaceutical industry, especially the wholesalers and the pharmacies, the operators, the proprietors. So I think the composition of your working group going forward, and even the composition of the PPP, I think you have to bear in mind the operating environment of the industry and ensure that they will be represented. It's not the case that all pharmacists are proprietors. Proprietors and pharmacists are two separate categories. So I think you gave a detailed explanation regarding the composition of the PPP, but you're talking about the professional bodies and the tertiary institutions. So I'd like to remind you, I'd just like to remind you of this. I'm sorry, Mr. Wong. The pharmacists were more vocal in the objection the other day, but I've forgotten to mention that the authorized seller of poisons, the working group on that, are represented by those from the industry. For example, licensed manufacturers and the authorized persons on that working group. All the licensed manufacturers are sitting on the working group, and they've also written in to express the support. We have set up 4 working groups. Working group of import and exporter and wholesaler of poisons. That is, all licensed wholesaler of poisons and manufacturers and import and exporters, they're all represented on that working group. For the authorized seller of poisons, you have Chantai, Manning, Watson's, Vanco, they're all represented in a working group. So other than the individuals, certain enterprises are also represented on those working groups. So the working group has actually comprised of different stakeholders. We have actually a full list of the membership of all the respective working groups. You also have listed out the dates when they had meetings, and also whether we even provided the dates on the number of consultations and public hearings that we've held and the deputations which have been invited to those sessions. So members may refer to that list. Mr. Wong Kwong made 2 points. First of all, I think the Permanent Secretary's response were technical in nature. For example, how many working groups have been set up and so on. I think members may have forgotten. That is, the question asked is how many codes COP and COC are there. Within the industry, there are several. So the Permanent Secretary referred to the paper where the details are listed in the column on the right-hand side. I think the trade is concerned how the 2 codes are to be drafted. Another point raised by Mr. Albert Chen and Mr. Wong Ting Kwong was whether we need to right now we have a system of self-regulation, but now with the new provision will be legally binding. Under 4B, is the drafting 4B typical of other ordinances? So how you have not spelled in detail how you're going to regulate the retailers and the pharmacies and community pharmacies. You've not given any details. So I think for this part, the administration give us another paper to explain I think how you're actually going to regulate is something else, and the proposed mode of regulation, as you suggest in this bill, I think in the medical profession and the broadcasting authority, such statutory bodies also have the power to issue such codes. So could you give us a list so that members can be assured that this method of drafting is also found in other legislations. Emily Lau. I'm sorry I've not attended all the meetings of this Bills Committee, but I'd like to remind the Deputy Secretary again that some deputations still have certain views, and when they sit in attendance to our meetings, and sometimes they even write to us. I'm sure if the Secretary has received such views, they will send them to us and administration. I hope you will liaise more and communicate more with the industry, and wherever possible, if it is possible for you to accommodate the views, please try your best to do so. Because right now people are complaining the administration is not listening to the public. So if there are reasonable demands and requests, I hope you will incorporate them, because they have come so frequently. Obviously, it is that some of the concerns, you've not heard some of the concerns. So please take some time to deal with that. Deputy Secretary, could you briefly explain to us as to whether or not you're still in dialogue with the deputations? Are you still, in a dialogue with them? Thank you, Ms. Lau. I'll ask Ms. Ng to supplement further. I think the dialogue was ongoing. Once after a public hearing, so we're told that there's some newly established organizations. We've tried to get in touch with them, and we've made an appointment to meet with them in June. But they're also very busy. Ms. Ng can give you the details. According to my latest understanding, they are not busy. So Ms. Ng can supplement on the point about how we try to make an appointment to meet with them. There is a new Pharmacists Association, the Pharmacists Union. The Pharmacists Union. We have been trying to make an appointment to meet with them. We had initially agreed to meet with them on the 20th of June. Unfortunately, they said that while there was that they will only agree to meet when lawyers are present. So that is why we have yet to finalize the meeting. But on other occasions, we've learned that these pharmacists, this Pharmacist Association would like to, give the inputs to the government. And on different occasions, we had the opportunity to explain to them our position and to listen to the concerns. And we will try our best to explain and to communicate with them. Chairman, I hope the deputations will make good use of the time because we're already doing the clause by clause of the bill. If the administration has made an appointment with them, I hope you will really have a discussion. But what about the other deputations? Are you still, seeking to meet with the other deputations? I think we've also been in touch with the Hong Kong and Kowloon Pharmacists Association, the Hong Kong, Association of, practicing pharmacists and so on. We've met with all of them already and explained our position and addressed some of the concerns and so on. What was the outcome? Don't just tell us that you've met with them. Do they continue to support your proposal or what? After several public hearings and consultations, we have extensively talked to different organizations. Other than those mentioned by Ms. Ng, we've also met with the tertiary institutions and also those who came to the public hearing. We've met with them in person and talked to them over the telephone. I'm sure the chairman and members have received many letters. We hope that they will write down the detailed views. That is, after we've met with them, they should write in and tell us what are their concerns, and we'll try our best to answer the questions. I think recently the chairman and members have received from the Chinese U and the Hong Kong U's Pharmacists Association or patient groups or oncologists who commented on the treatment of certain poisons. In 1810, 13, 14, in this document, we've listed all in this paper. the Hong Kong Drug Association, the Hong Kong Hospital Farmers Association, and the APs, like Mr. Wong said, the licensed, authorized persons. We've done another round of consultation with them, and we hope that they will write in to clearly, spell out their concerns. Chairman, I think the Deputy Secretary is right. We will listen to the views and try to assist them. If the administration refused to meet with them, of course they would have told us. But after you've met with them, were they happy or satisfied? Please tell us as well, because we are not able to follow up on the meetings that you have had with them. So that if you perhaps you can tell us, which part of the bill they support and which part they do not, and that will be helpful. That will help certainly be most helpful in. So I think the deputations, if you want to meet with the administration, to do so as soon as possible, and then the administration tell us whether or not you've dealt with the concerns, and if not, what are those outstanding issues, and then so that we can have a good grasp of the situation. Could the administration give us an extract about the concerns expressed by the different deputations, and what are your views? Of course, there are some that you've met and others you have not yet met with them. Mr. Chen. Chairman, I have a minor question regarding 4B. I'd just like to clarify my understanding, because I don't want to come back to these issues, these principles. In principle, there are some who are for and some who are against the bill. I think one argument now is the composition of the PPP. Is that the case? That is the composition of the PPP. The composition of the bill, PPP is not part of this bill, but it is. So it's not within the scope of this bill. Now, this bill does not address the composition of the PPP, and whether or not there should be separate regulation for drugs and the practitioners. And secondly, if you look at 4B, regarding the COC and the COP, I'm sorry, my question may sound a bit trivial. Are these targeted at the APs or all the stakeholders involved? Thank you, Mr. Chen. I think Mr. Wong also reminded me that I might omit this point. There are 5 codes of practice for practitioners. Under the ordinance, the people, the regulated persons, or whether it's the licensee or the registered persons, including the authorized seller of poisons code of conduct, and the code of conduct for the ASP, and the LSP, there is another separate code of practice, the list of seller of poisons. Import and exporter and wholesaler of poisons, there's yet another code of product. You need to apply the permit if you want to import and export or wholesale poisons, and then the licensed manufacturers and authorized persons, there's another set of code of practice. That's the code of practice for AP. There's a code of practice governing the manufacture of drugs, and to ensure that he is in control of the manufacturing process. And finally, the code of practice for the professionals, namely the pharmacists. We have 5 working groups, and the list will give you all the people who we have invited to sit on the PPP, and the days of the meeting scheduled are also on that list. So it's quite comprehensive. The AP, for example, Perm Secretary.
Now, can you be more succinct? 4B is about COC and COP. So you talk about 5 working groups. I think members are concerned about the working group's composition, the discussion, etc. And then apart from these, let's say if the bill is passed, then Under the new Cap 138, the PPB will have the power to formulate COCs and COP. And how many COC and COPs will there be to regulate what you've mentioned? There'll be 4 COCs and 1 COC. Now, I need to explain that this principal ordinance is very complex. These parties are already being regulated in the existing ordinance. I mean, they are regulated by the codes of conducts formulated by their respective associations. The PPB in the existing ordinance do not have the power to formulate the codes. So, in short, these parties are already regulated by the existing codes. So there will be 4 COCs to regulate ASP, LSP, exporters, manufacturers, so on and so forth. What about the existing ordinance? Is there anything similar at the moment? And there is also a code of conduct applicable to pharmacists. And you mentioned that there are 3 sets of codes of conducts issued by 3 respective associations or institutes. However, they're not standardized, and through this exercise, we'd like to have a standardized bill to regulate pharmacists. Thirdly, about opposition. Where does the opposition come from? The ASP, LSP, or what? So just to follow up on the issues raised by Mr. Albert Chan, so let me go through them one by one. There are 4 sets of CLP, and the existing ordinance doesn't empower PPB to formulate COPs. However, the PPB is responsible for licensing matters, and it can impose as a licensing condition that the licensee observe the COP. So it's a rather indirect approach. Every time a revision is necessary, the license will have to be revised. Now that's existing practice, but what we want now is to have a transparent and publicly accessible code so that licensees, even when applying for a license, can know what to observe. As for pharmacists, now we rely on regulation and codes issued by, or the Code of Ethics, issued by the respective associations, and they're set out in CB bracket 21584/1314. The 3 institutes or associations have codes which are drafted quite in general terms, whereas we contain more specific provisions in the code. Now, this is controversial, Chairman, about the codes for distributor, for pharmacists, so on and so forth. We understand there are working groups. What about the professional code of conduct for pharmacists? Why should the code be formulated by a working group under PPB rather than by the professional body? There is no controversy because the PPB is responsible for the registration of pharmacists. Now, currently, all pharmacists are required to apply to be registered under the PPB, but the PPB is not empowered. Then why can't we set up a board? Well, that's exactly the point. The ordinance was enacted in the 1960s, and the ordinance covered both the drugs and the practitioners, and it's difficult to separate them. That's why we set up a working group to discuss whether there should be an independent body regulating pharmacists in the future and how it should be carried out. Should it be something like the Medical Council? And on insiders, the professionals, or self-regulation by professionals. Again, this is a point of controversy. So if we were to separate the two, we agree that this should be the way forward. But this has not to do with the bill. The bill is about ensuring drug safety, medicinal safety. Now, these recommendations were put forward after the drug incident back then. Yes, I agree. But the new bill involves additional structure, new powers, new regulations affecting a profession, and this profession has its own professional body. I don't know how we should deal with the issue. Now, let me give you some background information. At present, after finishing a recognized course, a pharmacist must apply for registration under CAP 138 in order to practice in Hong Kong. Now, the DS told us the history about CAP 138 regulating both the pharmaceutical products as well as pharmacists. In fact, CAP 138 should not cover both. But does that mean that there won't be any self-regulation? The answer is no, because the PPB also comprises professional, pharmacists, and they're responsible for licensing. Whereas for doctors and nurses, they have the respective legislation regulating licensing matters. Whereas for CAP 138, it covers selling of medicine or pharmaceutical products as well as registration of pharmacists. In the administration's paper 1943/1314 on the last page, they say that, well, there will be a review committee, so on and so forth, and there will be further discussion. I don't know if that's true or not, but it has nothing to do with this bill. It doesn't change anything about registration. Now, this bill has to do with with one addition, that is 4B, involving codes of conduct and codes of practice. Which are binding on pharmacists, on manufacturers, exporters, ASPs, etc. That's the background. I think Chairman has made it very clear. I just want to supplement that about the COC proposed, say for the COC for pharmacists, that's one of the recommendations made after the drug incidents back then. That is, in handling drugs, each and every step in the process should be set out very clearly, because it's a supply chain from manufacturing, distribution, retail to management by pharmacists. That also explained why the ordinance apply to both products as well as practitioners. It's outdated, and we're willing to review it. In fact, the working group mentioned just now has called for a meeting, and towards the end of the year, there'll be another meeting called for to look at the regulation of the profession, whether a new piece of legislation is necessary, so on and so forth. As I said just now, in the PPB, there are 3 members representing the industry. They are nominated by the Pharmaceutical Society of Hong Kong and approved by the Chief Executive. And there are also representatives from the Chinese University and the Hong Kong University. So the pharmacists are represented in the PPB. But apart from these representatives, there are other members, of course. I hope when members discuss this issue, as Chairman says, we must bear in mind that the bill the bill contains recommendations made after a series of drug incidents to ensure public safety. Now, as to the way forward, whether the whole CAP 138 should be revamped, we're willing to have a discussion, but we mustn't wait for it because it will be very unfortunate to have any more drug incidents. The last incident happened in 2009. It's quite far away, and what we're doing is to implement the rest of the recommendations. Ms. Claudia Mo. Now, on this part, Pharmacy and Poisons Amendment Bill 2014 is complex. We can all see that it involves legal matters. It involves the pharmaceutical industry. Now, just now, I heard that the administration is happy to discuss with the profession. Then you said that you're awaiting their views. I think we're going round circles. The administration is proposing something new to regulate. Me, let's say I'm a pharmacist, and I have made myself very clear that I'm not happy about certain matters. And even if we have meetings, things will just be repetitious. The bill will just be passed in the end. Now, you say that this bill doesn't involve composition of the PPB, but what we are concerned is that it will be too late to speak out. Because since the bill is passed, the PPB will carry on its business as usual. Now, the code of conduct, there'll be a set on for pharmacists, and there'll be 4 codes of conduct, 4 codes of practice. Pharmacists are professionals. The Medical Council is an independent body. So why is it that pharmacists cannot set up their own body? Now, you seem to say that you'll see how it goes in the future. But I'm concerned that by then it will be too late, as everything will be settled and we'll have no further say on the matter. So can you give the industry a clear message that this exercise is done on this occasion really out of good intention, and there is no intention to really stifle the pharmaceutical industry and also the pharmacists. Thank you, Ms. Mo, for your question. First of all, pharmacists, it seems, are not objecting to having the code.
After our meeting with them, we've actually approached many different organizations. We deliberately consulted the universities, the Hong Kong University's Pharmacology Department. And they actually had attended the hearing, Mr. Ian Wong from the university. We had a further consultation on the code of conduct. In his letter to the chairman dated the 4th of June, which has been circulated as well, he said the promulgated the code of practice
also upgrade the standard of the pharmaceutical profession.
They're in support of that.
Did they actually say that they welcome such regulations by the government?
They may not be referring to the bill here.
I'm not too sure what you're quoting.
I think the letter has already been circulated. If you wait for the Permanent Secretary to finish first, it's addressed to the chairman. The Chinese university also said.
Amendment bill，因為佢用英文嘅，所以我就照讀嘅啫。咁我亦都唔再嘥大家時間啦。佢哋係支持嘅。
So they are also in support of the amendment of the ordinance. There are also professional organizations which have written in. We have already listed all the names of those organizations which have written in the paper for Let's Go. According to our understanding and from my inquiry with them, they would like to, in the long term, separate the regulation of practitioners and the regulation of drugs. So we will need to discuss that in detail. Even if we were to set up a legislation to regulate professional pharmacists, it's no simple task. So how should we do it, and what should be the composition of that body? I think we need to talk to the profession first. Pharmacists may work in hospitals or in community pharmacies, so we need to consult all of them. And also, they have a close relationship with the drug manufacturing industry. So, regarding the need to have a separate legislation to regulate pharmacists, we do not object to that. What we're saying is that we need to talk to the trade about the direction that we should take in this respect. But what I'm saying is that while we need to discuss that, it has nothing to do with the bill. So we can do both at the same time. So the paper referred to by the Permanent Secretary is CB 1767 1314 and that is actually the a letter from Professor Wong of the Department of Pharmacology of the Hong Kong University. And if members have any further queries, you can clarify with the professor, personally. Vincent Fang. Chairman, first of all, I must apologize for being late because I needed to attend another meeting. I think if requiring the ordering of drugs to be in writing can help prevent the medical incident which happened in 2009, I'm more in support of that. The administration has responded to my earlier letter. In paragraph 2 of your response, you say in 2009, within the course of 5 months, there were 153 incidents of patients being dispensed with the wrong drugs, and I think this is a very serious problem. So, of the 153 incidents, have you followed up on those incidents, and had the patient's health been seriously jeopardized because of that? And had any doctors or persons made any mistakes, and have they been, and if so, have they been punished? If you say that requiring the ordering of drugs in writing can prevent such incidents, and I'm all in support of that, but I'm not convinced that it really can resolve the problem. And secondly, we had a very heated argument just now about the COC and the COP. And I think we've worked on the bills many times, so once the bill the administration always say that once the bill is enacted, the government will issue codes and guidelines for the respective trade. But we always, each and every time, however, the codes which are issued subsequently are so stringent that the industry find it very difficult to comply. The bill is very complicated, and the administration again is saying that these are the guidelines, and the administration said it's willing to communicate with the industry. But you stipulate that this will come into effect on the 1st of January 2005. Now, if the bill is so complex, as you yourself have said, Chairman, should we split up the principal ordinance into two parts to regulate pharmacists and drugs? We haven't yet decided. And you've already decided that on the 1st of January next year, this will come into effect. And then the codes or guidelines you've drafted has been circulated to industry. But I think the trade has very strong reaction to the guidelines that you've drafted. So how can you ensure that come January 1st next year, this will come into effect? You say this is a bottom line. Whether or not the trade accepts or not, you will still implement the new regulations. So is it your bottom line that the commencement date will be the 1st of January next year, even though there are objections from the industry? Chairman, I'll try to answer the various questions. First of all, the date of January 1st, 2015, I think there's some misunderstanding here. Right now, the ASPs already has a licensing regime, and under that licensing regime, one of the licensing conditions is that the PPP would require them to abide by certain codes. The working group has already endorse a new set of code of conduct after detailed consultation, and all the ASPs participated in the process, and they also supported a new code of conduct. So the code which will be implemented on January 1st is issued is related to the licensing conditions. So so what's the difference here? The code in the past was part of the licensing conditions, and there is no question of disciplinary sanctions. If the person breaches the code, then the worst that can happen is that you deal with him when he applies for license renewal. However, under this bill, with the newly added Section 4B, that is after we've issued these codes, and any failure to comply would result in disciplinary sanctions such as warning letters and so on. But even if you breach the code of conduct, doesn't mean that you've broken the law. The code is not a piece of legislation, and that's why we have the date of January 1st, 2015. We're not saying that we think that the law will definitely come into effect on that day, but the 150 medical incidents did not happen within the course of 5 months, but rather 153 patients were administered the same drug which were wrong, and the doctor continued to dispense the wrong medicine to 153 patients over a period of 5 months. So the error arising from the drugs, from the verbal ordering of that particular drug, resulted in 153 patients being affected, because an order involves a big lot, and when a mistake is made, you wouldn't realize that until many people have been affected. Of course, I agree with Mr. Fang that requiring the ordering of drugs in writing will prevent all medical incidents from happening, but at least in the course of shipment and the ordering of the drugs, we can minimize the possibility of error. And we've also tried our best to assess the impact. We have promised that even for ordering of drugs verbally or in writing, we'll do it in phases. Initially, only the ordering of poisons would be required to be made in writing. The more risky and dangerous ones, we will start with those first. Hopefully this can help minimize the impact on the trade. For pharmacies and seller of drugs and the wholesalers, they welcome this actually, because they think that it's not possible for them to return accept the return of drugs, because whenever drugs are being returned, the manufacturers will not dare to sell them again. They will simply dispose of them. So we are saying that the order has to be done in writing. It could be by fax or SMS or by email or in writing. And after the doctor has made a telephone call, and then the vendor will confirm the order in writing, and the doctor agreed, that would also be acceptable. So we really tried our best to minimize the inconvenience. We're doing all that because we want to plug all the loopholes which gave rise to the medical incident. Of course, we will still need to find out whether there are other problems. We are not saying that we can resolve all the problems. As to whether or not the code will become more stringent in future, I've already said that on the working group we have representatives from all the licensed ASPs. We will consult them. We invite them to sit on the working group so that we can work out the code together. And the code of practice, I think there will also be representatives from the industry on the PPB. So it will not be simply, endorsed quietly. The whole process will be transparent. And if the trade has any inputs to you, suddenly you will also take the issues to us. So that I'm sure the process will be very transparent. Mr. Fang, you said that there were 153 medical incidents over the course of 5 months. We're talking about the clinic in question. You need to regulate the manufacturers, the pharmacies, the wholesalers, and the retailers. I understand you're going to do that. But for this particular incident, it happened in a medical clinic. Have you ever considered that how will you tighten the regulation of these clinics if the same mistake was made 153 times and it happens in a clinic and it concerns the doctor and the person who dispensed the drug? That was the source of the problem. How are you going to resolve that? Well, the requirement is for the doctor to order drugs in writing. For poisons already, orders have to be made in writing already. For the wholesalers, and for poisons on the poisons list, the participant will need to keep records, and the doctor will need to obtain a license before he can dispense poisons, as you've said. In the clinic, if the drug stopped when it reaches the clinic, and the doctor can order the poison verbally, and he doesn't need to keep any records. So the code now says that when the doctor orders the drugs, it would need to be done in writing. For the wholesalers of poisons, they are already governed by the requirement that they need to keep records. Of course, even if you order the drug very clearly in writing, and if the nurse in the clinic make a mistake, and while the label, if you wrongly label the drugs, then shouldn't you also, regulate that as well? Everything is in order at the front end, but at the final end, when at the clinic, at the level of the clinic, why are you not regulating that as well? Can CAP 138 regulate the medical clinics? No, because no. So how do you regulate the clinics? We can only regulate the doctor because the doctor is responsible for his clinic. I understand Mr. Fang already said that requiring the ordering of drugs in writing cannot resolve or prevent all human errors, but at least for 153 incidents of the drug being wrongly dispensed, it's not that the nurse repeated the same mistake 153 times, but rather he ordered, drug A and drug B was delivered, and the wrong drug was put into the bottle. So the same mistake will be made when they, dispense the drug. As to whether there's a better way to prevent human error, we can certainly look into that in future. But it's not something that is within the scope of the bill. I think Mr. Vincent Fang's question is that everything will need to work together. For private medical clinics, of course this is not, the topic of discussion today, but could you give us some information as to how you regulate private medical clinics at the moment? Actually, we regulate the doctor. On the day in question, the doctor did not. We're talking about the incident in 2009. No, I'm saying that in general. What I'm saying is in general, for a private medical practitioner to set up a clinic, how does the government regulate him, or does it only require to obtain a license? Actually, there is a code of code of practice, governing the doctors. And according to the Medical Council's code, doctors will need to order drugs in writing. But right now, there is no such requirement in the ordinance, the part of the ordinance governing the drugs.
Under the Medical Association, the association recommends doctors place written orders for drugs. So, but as this code is not legally binding, it's formulated by a professional body. The doctor, in the end, was found to be in professional misconduct. So he was regulated. He was found by the Medical Council to be in professional misconduct. Whereas here, if the doctor doesn't comply with the code of conduct, as the written order is required for him to place order with the drug seller, so we have extra security here from this side. Now, Mr. Fang, Cap 138 is now proposed to be amended to such that in the future, order for drugs will have to be placed in a written form. Let's say if it's a private clinic, then the private clinic is licensed by the Medical Council, and then about the operation of the clinic, theoretically the doctor will be responsible for the operation. But let's say if the doctor wants to place an order by phone with the manufacturer ABC, then sorry, now it's not possible. A written order will have to be made after dispatching the order, and then when the drug comes back to the clinic, if the nurse or the doctor then erroneously places the wrong drug in the bag, then it's the fault on the part of the doctors and nurses. I understand this point, but if there are no corresponding measures regulating doctors and nurses, you will still see the same mistake about the 150-something repeated errors back in 2009. How did this happen? Of course, the drugs, the requirement for placement of order for drugs is important because you want to prevent mistakes. But on the other hand, on the side of clinics, there should also be something corresponding. It's just a simple mistake, but it was repeated 150 plus times. So it's too lax. That's my point. And also for poisons, yes, you say that the retailers are required to keep a record in writing, so on and so forth. But is there any regulation over the use of poisons at clinics? Ultimately, it's the clinics that are users of poisons. So the government has to regulate both. If you just regulate one end and not the other, the mistakes will just be repeated. No matter how clearly it's written or typed out, at the other end, if there is no regulation, there will still be mistakes. That's my point. I don't know anything about Cap 138, 192, but from the perspective of a patient, my view is that you cannot just regulate one part. You have to do it comprehensively, so that throughout there won't be any mistakes, so that you can really protect the patients. DS, can you? Now, I think today's discussion is not about regulating doctors. Can you give us some information after the meeting, telling members the existing regulatory framework on doctors, on their prescriptions, so on and so forth? Although this is not this shouldn't be the scope of the bill, but please give us supplementary information. Any other questions from members? If not, it's now 12:30. It's still 15 minutes away from the scheduled end time, and I see that we have not thoroughly discussed 4B. We have examined 4B once, but it doesn't mean we're agreeing to it without any amendment. I think if necessary, next time we can discuss 4B again. We have 15 minutes left. If there are no objections, we'll continue to with other causes. Mr. Fang, please stay on. So please move on to page 7, section 5. Now, on the Register of Pharmacists, section 5 on page 7, Mr. Fang. We have so few members here. Well, last time we already agreed that we would pause where appropriate. Well, of course, we can adjourn the meeting now, but alternatively, we can continue with the scrutiny, and if a discussion is necessary, we can go back to it. Well, I'm the only member here. If I leave, I don't think it's pointless to carry on the meeting. We're approaching the end of the meeting anyway. Don't start anything new. I'm the only member here. All right, understood. So Mr. Fang should not be solely responsible. All right, some are technical amendments, not controversial. I thought we could continue to scrutinize them, but we have 15 minutes left anyway, so let's have lunch and discuss it next time. So, meeting's adjourned. Thank you.